The next painter and obviously the next presenter will be Joy Shabot, who is a shareholder at Greenberg Trarig's Tel Aviv office. Joy, please come here on stage. The role of the GC in protecting and communicating with the board.
Thank you. Thank you very much. Good morning, everybody. Delightful to be here. It's really amazing and tremendous to take this room in. I mean, there's representatives here of the entire cross-section of Israel's economy. You guys represent tech, finance, industry, real estate, services, others, and it's a tremendous show and display of the diversity of this economy, the depth of it, and the maturity of it. So give yourselves really a hand of applause because you deserve it. And it's such an honor to be a part of this gathering. I'm going to start with a few stories before I really sort of introduce the topic. I got these stories from a book by a real kind of thinker on the subject that we're going to talk about, which is the relationship between the board, the CEO, and the general counsel. It's Ben Heinemann. Ben Heinemann was formerly the general counsel of GE and is now a teacher at Harvard Law School and a thinker on these issues. I really recommend his books, in particular the latest one, which talks about some of these very tensions. I'll mention the case studies, and then at the end we'll sort of come back and think about them again in light of some of the ideas that we thought about. In the 1990s, and this is going to be familiar to probably everybody in the room, GE personnel were implicated in a fraud against the US government involving the purchase of equipment from GE by the Israeli military. This was a program that provided U.S. money to the Israeli military to purchase U.S.-made equipment. In this case, it was GE aircraft engines. After conducting an internal investigation, it was pretty clear to the management of GE that there was some fraud that had taken place. There was misappropriation of U.S. government money, including a 30-year veteran and the head of one of the most important business units of GE who was involved. Story number two relates to a price-fixing situation where the United States Department of Justice, the Antitrust Division, sought to bring criminal charges against GE in connection with sales of certain diamond manufacturing and mining equipment. They were going to go to the GE was faced with the question of, do we go to trial, do we settle? There was a settlement offer on the table by the government. It was a criminal investigation, and in the United States, it's extremely rare for a company to choose to go to trial when there's a settlement offer being offered. Very, very risky in many ways, because in particular it was a criminal charge. The third relates to another GE product, and this GE is such an amazingly big company that you kind of get all these diverse examples, is ultrasound equipment. In the 80s and 90s, as ultrasound equipment was becoming cheaper and the markets were opening up in China and in India, there was an opportunity for GE to enter those markets by selling ultrasound equipment that is used, among other things, for determining the sex of a baby. The GE management understood and knew about a problem, especially in China, but also in India, of sex selection abortions, whereby parents and physicians would use the equipment in order to determine the sex of the baby such that and to prefer boys over girls, such that they would perform abortions on this basis. Abortions are legal in China, but there is a prohibition on using knowledge of the sex of the baby ahead of time to perform a sex-based selection of the abortion. So in China, it is illegal. And also in India, it was and is illegal to actually perform abortions on this basis. But this was a rule that was on the books and was more kind of observed in the breach than it was in the observance. And GE was faced with thinking about its role in this issue. And do we sell this equipment, and how do we sort of deal with the ethical problems that are involved in selling into this market? If we deal with them at all, is it even our responsibility? Because after all, this equipment is not just used for this purpose, it's also used for life-saving and other very important diagnostic uses. We'll come back to these three case studies, and I'll tell you sort of the outcome of each of them, which I think is very informative and kind of posits some of the issues and the tensions that the General Counsel should be involved in determining for the corporation. Today's practical ideal of a modern General Counsel is a lawyer statesperson. He is or she is an outstanding technical expert, a wise counselor, an effective leader who has a major role assisting the corporation achieve the fundamental goal of global capitalism. For the lawyer statesperson, the first question is, of course, is it legal? As we also heard Eyal say and others, another question that must be asked is it right? Is it ethical? Are there any great questions in this issue? This vision of the General Counsel is evolving, and in the United States, certainly, but also in Israel, we see a continued evolution of the General Counsel to becoming more and more central in dealing with some tensions within the organization. This revolution, as Heinemann refers to it, began in the late 1970s, and it has increased in scope and power ever since. Working with the CEO and other senior executives, the GC must forge an unbreakable bond between performance on the one hand, but also integrity and risk management on the other hand. There are always sets of foundational corporate issues. There's business strategy, but there's also culture, compliance, ethics, risks, governance, and citizenship of the company and the world. To do this, the General Counsel must resolve the most basic problem confronting inside lawyers, being on the one hand a partner to the board of directors and to the CEO and the business leaders, but on the other hand being the guardian of the corporation. This practical ideal is attainable because the General Counsel and inside law departments in outstanding corporations have become far more sophisticated, capable, and influential, transforming the realities of both business and law in several important ways. It also needs to be noted that today's inside General Counsel are generally graduates of major law firms, sometimes even partners from those law firms. And so that has resulted in a shift of power from outside law firms, which again in the United States at least, in the earlier years were the most trusted and the go-to sort of resource for the CEO when they needed complicated advice, and now really resides more in the in-house legal department. That is a reflection both of the fact that they handle more and more complex matters without always resorting first to outside counsel, but also because of their focus on money and budget management. And as you are probably all aware, management of the legal budget is becoming more and more the province of the General Counsel, and the responsibility to sort of limit and understand the way in which the legal budget is used. Because these corporate law departments have increasingly staffed by outstanding experts who are generally graduates of top law firms, inside lawyers have taken on day-to-day management from strategic direction of major matters affecting the corporation, cross-border transactions, multi-front litigation, international enforcement, and so on. The General Counsel and inside lawyers have strongly reasserted control over the money spent on outside law firms, focusing on cost control and front-end budgeting and negotiating fees, and even doing back-end audits and cost disallowances, and moving away from just preferred provider relationships to more strategic partnerships. Also emphasizing use of technology and innovative third-party vendors, especially in litigation, to reduce outside law firm spend. Greenberg Traurig, I'll say in a moment a little bit more about the firm, is a leader in this particular way of thought, and we are really founded on the idea that we are a law firm of the next generation that is also very focused on efficiency and cost cutting. On the critical risks and opportunities that involve the questions of so-called business and society issues, boards and business leaders now delegate major responsibility and key outside relationships to the General Counsel to help reach its commercial and citizenship objectives across a minefield of different issues of policy, law, enforcement, and also public scrutiny, headlines, like the tax inversion example, which is always cited, which, doing things that are perfectly legal, but which in the mind of your customers, of your other stakeholders, when they show up on a headline, really does not look good. Two related sort of aspirational roles that are key to today's General Counsel vision. There is a governance demand, and going back to the role of the board, the board cannot manage the corporation, right? The board is to oversee the corporation. So this oversight function is something that the GC is expected to help the board accomplish. Defining the corporation's citizenship means that the general counsel must balance this constantly. The need for the board to be informed, the need for the board to be the one that is setting policy, but also, of course, keeping in mind the CEO, who is the direct boss of the general counsel, and on a day-to-day basis, who must be satisfied and whose mission for the company must be executed upon. But there are also other stakeholders that must be kept in mind. There are the employees, the corporation's long-term well-being, the rule of law generally, and the administration of justice, because as lawyers we are still consider ourselves, I hope, although sometimes it seems less and less, as officers of the court in some way, or officers of society who are in charge with more than just the four corners of our job, but also we're responsible to society as a whole. The GC is also a key player in vital leadership tasks of creating a culture that we heard about from Eyal and Lior, of high performance but also high integrity. The tone at the top, which the CEO is the one that sets, as Eyal said, is one that must be carried forward most prominently by the General Counsel. In helping fuse high performance with high integrity, the General Counsel, as lawyer statesman or stateswoman, must engage in robust debate on major corporate initiatives of all shapes and sizes. What are the ends of the action, not just what are the means? Not just how do we accomplish, and in this way maybe I differ slightly from Eyal, but also why are we doing this, and is it okay for us to be doing this? Purpose, not just process, about what is right and not just what is legal. A lawyer statesperson must function simultaneously in the three fundamental roles of what a great lawyer is always traditionally considered to be: a technical expert, a wise counselor, but also as an accountable leader in themselves. They are not just a tool for performing someone else's objectives, but also someone who is themselves a leader within their organization. In particular, if you are leading a legal department that consists of additional lawyers who are looking to you for guidance in setting this tone. The corporate general counsel must ask questions like, what should be, not just what do we do? And they need to have knowledge beyond just the law, but also some degree of financial, scientific, and technological literacy. So you guys have a really hard job. The General Counsel, and this is I think the key, must serve as partner to the board of directors and the business leaders, and again as the guardian of the corporation. The fusion of this partner role on the one hand of making sure that the mission and the policy is executed upon, but also as the guardian, depends on the GC's integration into the management of the company and into the core activities of the corporation. There are many obstacles to this fusion, and they cast doubt on whether a general counsel can effectively perform this mission. For example, some business leaders' lack of understanding about the interaction between law and policy. Anti-lawyer sentiment in our cultures, and this is true in the United States, it's true in Israel, general anti-lawyer sentiment that lawyers are people who get in the way of things and are not problem solvers but problem makers, and lawyer jokes and so on and so forth. The fear of CEO retribution, because after all the CEO does have the power to fire and hire in most cases, a word about this a little bit later, and group pressure generally, just to name a few. These obstacles can be overcome by the independence and courage of a general counsel, by alliances with key staff leaders, and not just the CEO, but also the CFO, the head of HR, and other key staff, and by close relationship directly with the board of directors. But at the end of the day, it is the relationship with the CEO that controls. The CEO, like the board of directors, must have the vision of high performance and high integrity which are married to each other. It must affirmatively want the general counsel to be a lawyer statesperson and partner guardian, never afraid to speak out on what is right for the corporation. In thinking about some of these ideals, they're very aspirational. I put together what I think is a list of kind of best practices or ways in which companies can really sort of seek to achieve this. And thinking about them first from the perspective of the general counsel, what are things that the general counsel should do or should insist on doing, on having be done in the company? And on the other hand, what can the board be doing to empower the general counsel so that they start to achieve this aspirational role more fully? The general counsel should have constant and direct contact with the board of directors in various settings. as well as with individual board members. Relationships between the general counsel and the board members that are direct should be encouraged. There should be some kind of context or ability to have individual contact with directors. For example, even on mundane things like the directors wanting to ask questions about things that are going on in the company without necessarily having to go to the CEO, who's generally much more busy than even the GC. That's something that should be encouraged. The GC should also be part of the board culture, by which I mean the board, if they have board dinners in connection with meetings, annual meetings, if they have board retreats, if they have a business trip together, the general counsel should be included and should seek to be included in that sort of those cultural activities that cause the board to be a more cohesive unit. The general counsel, of course, should attend all board meetings, but also all committee meetings for the purpose of taking minutes and being available to answer questions. The general counsel should also not just see themselves as the sort of note taker, but should not be afraid in appropriate circumstances, of course, to speak out independently and if necessary, forcefully, for example, to clarify a matter that maybe is not being explained in a clear way, but also to take a position and a view when that is mandated by the situation. The GC should not be an underling, an obedient, employee, but rather should really seek to develop their own independent character and presence in the board meetings. As I mentioned before, the one-on-one meetings should occur and should be encouraged. These generally should be invited by the board, so maybe this is more on the board side of things that directors should be doing, because after all, we don't want to disrupt the balance of the relationship between the CEO and the general counsel, and the CEO doesn't like probably generally the tension that is associated with the general counsel sort of going directly to the directors and over his or her head, so to speak. So then the directors should initiate those kinds of contacts because they enable the reporting up in appropriate cases without fear of retribution. Again, of course, these things are aspirational and need to be balanced. When we're addressing these issues, sometimes it seems like we're overemphasizing them, but they need to be sort of taken in context and as part of an organic relationship. On the other hand, the general counsel should not be a member of the board generally. This has sometimes happened, but really should not happen because the client is the board in a way. The corporation is the client of the general counsel, and the board is the one that ultimately embodies who is the corporation. And so you should not be client and lawyer, of course, at the same time. The board should, of course, hear presentations from the general counsel at least once, twice, 3 times a year on risks that are facing the corporation, trends in enforcement or in litigation in the industry, in this company, and other issues that sort of are occupying the majority of or a significant amount of the general counsel's time. And those reports should be made directly to the board of directors. On the board side, there are things other than sort of what I said before, which is encouraging that direct communication when sensible, that the board should be doing. And this is not always very common. For example, I like the idea that the board should be involved in hiring and in firing the general counsel. That doesn't mean that the board decides, the CEO decides, and it doesn't mean that the full board needs to sort of pay attention to this issue, but there ought to be someone or a few someones who interview a general counsel candidate, because that, again, sort of at the very early time strengthens the idea that there is also a direct relationship between the board and the general counsel. And also there should be some kind of policy in place that the board should be advised and consulted before the dismissal of a general counsel, because the board should know the reasons and the context for that dismissal. That doesn't mean, again, that the general counsel reports directly to the board. The general counsel should report to the CEO, and ultimately the hiring and firing decision should be the CEO's. But again, it would be a good sort of check and balance to have that additional procedural step of consulting with the board be an express expectation when you're dismissing a general counsel. Along the same lines, the compensation of the general counsel should be something that the compensation committee of the board decides, or at least takes under advisement and makes a recommendation to the CEO about. And those compensation metrics should include long-term compensation or long-term equity compensation in order to align the mission of the general counsel with what should be the overall mission of the corporation, which is to generate long-term value and not just focus on the immediate year or the immediate job at hand right now. So those are some practical ideas to think about in designing the relationship between the board and the general counsel. Before I tell you the outcome of the stories that I started with, I want to just pause for a moment and acknowledge the presence of several of my colleagues. We have here Gary Epstein, who is the managing partner of the Tel Aviv office of GT. And we are joined also by my colleagues in the Tel Aviv office, Adam Snukel, Lauren Sternthal, Ephraim Schmeidler, and Devorah Snyder, and Sarah Dahan and Donna Chagall. So thank you for all your support by coming here today. And we are joined by several of our international colleagues. I don't know if the map is up. Can you put the map up of our offices? Whoever's doing the audio visual, or do I do it from here? Hello? Do you know how to do that?
Mentally.
Mentally?
You put it on, just put it on and we'll do it. Just put it on F5. Just put it F5. How do you put it?
Oh, got it. Thank you. So here you can see our geographic spread. GT is located in 38 locations, 29 in the United States, and in Israel. We are the only large international law firm with an active full-service office in Israel, where we have lawyers working here full-time, including myself. I moved to Israel 5 years ago. And we are joined by several of our international colleagues. Hillary Bass, who's co-president of the firm, and the president-elect of the ABA is with us today. I am not Rudy Giuliani, in case I should have said in the very beginning. I'm the other GT shareholder who's speaking today, but Rudy Giuliani is joining us, and he will be here shortly. Keith Shapiro from our Chicago office is here. David Schulman from Atlanta. Brad Kaufman from Miami Beach. Bob Grossman, who is the co-founder of the Israel practice and very active in Israel, is also here with us from Miami. Mark Mukasey from New York, who is a white-collar and FCPA investigations and litigation lawyer. Barry Schindler from our patent practice, who is very active in Israel, and many of you know him. One of the top patent lawyers anywhere, I hear, although I'm not expert in patent matters. And Joey Kaiser. So thank you all for your support by coming here and for making a good showing. The stories that I mentioned before, so here were the outcomes. And I hope you find that it is consonant with as I did, with the kind of some of the tensions that we discussed. And I think that they were not clear-cut answers as to what they did. On the issue of fraud and the U.S. government misappropriation of funds, GE General Counsel's office made a recommendation, which was accepted, to self-report. And they, after they conducted their evaluations and their internal investigation, which is privileged, they sent a copy of their own internal report to the SEC and to the Department of Justice and self-reported. And they negotiated fines and penalties and so on with them, and then they also fired, which was probably among the most difficult decisions that they had to make, this 30-year veteran who was ultimately responsible for this particular unit, who was again one of the most senior people in the firm and very, very valuable employee. On the other hand, sort of in contrast, the price-fixing scandal that was alleged, they decided to roll the dice on that one, and they said, we looked into this issue. We don't think we did anything wrong. We will go to battle with the government. And so in a very, very unusual move for a large company, they went into a criminal trial that was prosecuted by the Department of Justice, and they won. So they rolled correctly, but the decision To make that, the decision, of course, came ahead of the knowledge of how it would come out, but it was grounded in a certain belief and a certain sort of risk assessment that was based on sort of a factual determination. And also not wanting to be a pushover to the government. On the sex selection abortion issue, which in some ways is the most nuanced because it involves non-legal sort of ethical considerations, they decided to go down a path of so-called minimization. So they sold the product into China, and they were not willing to give up the profits and the sales associated with the sale of the ultrasound equipment. And they were not, of course, did not think that they should, even ethically, because of the other uses of the equipment. But what they did do is think of ways that they could minimize the potential harmful impact that was grounded in a moral perspective that these sex selection abortions were wrong by taking a few steps. They only sold to licensed practitioners and licensed institutions, which in China represented a significant cut of their particular market share because these machines were becoming so affordable that almost anyone could buy them who was giving health services. And they also told the people that they were selling to that they would inform the enforcement authorities in China who are responsible technically for enforcing the law against sex-based abortions of who owned this equipment, so that they could then, if they chose, perform inspections or enforcement such that they put a little bit of fear into the hearts of the users. They also clearly labeled each and every machine with a statement that it was against Chinese law to use this equipment in order to perform same-sex discrimination, sex-based discriminatory abortions. And they implemented a very thorough and popularized training program for physicians to try to kind of inculcate in them the compliance with this particular provision of Chinese law. So this was how they sort of struck the balance. And I found these instances very interesting, very challenging, because without knowing the answer, you kind of ask yourself, what would I do? And at the same time, very showing the way in which the General Counsel could really add value in making some of these difficult decisions. Thank you very much.